Nagorno-Karabakh. There's no example whatsoever of any Armenian unit on the ground, but there needs to be control over the court system. It's not enough to show that there is influence. It's not enough to show, as they keep saying, that Armenia is a party to the conflict. They've got to show that the strings that Armenia pulls, as they claim, are not just charitable donations, not just the fund, not just interrelationships, but actually are strings making judges puppets. And the cases that we've produced show that Nagorno-Karabakh judges are not puppets, they are independent. Can I move to, I think, Judge Village's question, what have Armenian courts got to do with this at all? Because the answer to that, and we entirely agree, we say that the evidence that we put on shows that the claim against the Armenian army is no good. Because if you read the applicant's statements, and I approached them as if I were formulating a claim, they all say that we were bombed and shot at by the Armenian army and air force. Now, that's their claim. So, on that claim, they can come to Armenia and sue the army for alleged wrongdoing in the air force, even though we point out Armenia didn't have an air force at the time, and the dispossession was by the Nagorno-Karabakh army. So they've got a choice, in a sense. They can come to Armenia and sue the army for extraterritorial wrongdoing in the courts of Armenia. We've put on a statement by a local lawyer saying, of course, that Armenia courts can give damages for wrongdoing by the army anywhere in the world. But, of course, if you read our statements, it's obvious that they're misconceived, when they describe the Armenian army, they're really talking about the Nagorno-Karabakh Defense Force. And, of course, if they sue in Nagorno-Karabakh, they have the additional ability to get their land back, because they can get restitution, because they'll re-register them, as they did in the Zafarov and Aleyev cases. So we say, look, your claim as formulated is a claim that's justiciable in Armenia because it alleges the Armenian army wrongly destroyed their home. If that's right, if you get that up, then you get damages in Armenia. But in fact, the evidence is that Armenia wasn't there at all. They were in barracks, and it was the Nagorno-Karabakh army who had possession, as you say, of your property. So you can sue you can get your additional remedy in Nagorno-Karabakh. Now, so that is the answer to Judge, your question. It's not that you've overlooked anything. It's simply that their claim is against the Armenian army, and so they have a right, they have a remedy if they can make good that claim, even though the evidence is that all they can get in Armenia is compensation. They can get compensation for distress and so forth, and for the loss of their property, destruction of their property. But if they want their land back, of course, they've got to go to Nagorno-Karabakh. Now, can we guarantee that the statement of the Nagorno-Karabakh judge, the Lachen judge, is still valid today? Well, of course, we can't guarantee anything in Nagorno-Karabakh because we have no control over it, effective or ineffective. But, and so we cannot speak for it. But his statement was taken when when the agent of the Armenian government and myself went to see him in Lachen in July, I think, 2012. So he emphasized that the European Convention would apply and that he was entirely independent of Armenian authorities, and that he would give disclosure, he would order, he said, government representatives to come to court and face examination. And that statement was supported by other people in the administration in Lachin. So to that extent, that statement is entirely credible, and he evinced to us a desire to assist the court if his evidence wanted orally. He will certainly assist any fact-finding mission. The latest cases, and I regret this, there has been, unfortunately, some confusion with the registry in a number of matters, but these were put up on the portal on Monday, and we assumed that they would go to the judges in the other parties. Our assumption was wrong, but they are there in a body of material that was put on the portal in relation to this case on Monday. We're sorry, of course, Ms. Butler and her team should have the opportunity to read them and make any comment they wish, and perhaps in the 2 weeks that we could be permitted in relation to written material, that can be done. But they are document 9 and document 10. The Zafarov case is case 2/260 of 2005, and the Aleyev case is /2281 of 2003. Both were cases in the court of Nagorno-Karabakh, first instance at Stepanakert. Both cases were successful. We are told there was no appeal, and you will find them there. They are almost identical cases to the applicant's case. They concern IDPs who fled, who found that they could get a remedy because they inquired of Nagorno-Karabakh representatives in Russia. They came back, they sued, the local authority refused to register their land, they took them to court, and the local authority was ordered to register their land. Now, the sixth question, any legal... we weren't sure whether this question was asking whether there was any law that prevents ownership of land in Nagorno-Karabakh by Azeris. If that was the question, there certainly isn't. There is indeed laws against discrimination on race or ethnicity. If the question was whether there was any law that prevents expropriation by the Nagorno-Karabakh force of Azeri land, then there is, as we say, a rule against discrimination, and you have the cases of Zafarov and Aleyev that show that you can get your land back if you are Azeris who have fled. Now, the seventh question concerned passports, and the evidence that we put on in our 2013 submissions show that you cannot, a Nagorno-Karabakh citizen cannot get passports as of right. There's a highly formal process. You've got to show humanitarian reasons. And we put on evidence of a case where a gentleman showed that he could only get medical treatment in Frankfurt. And so that evidence was sent to the Armenian authorities. They looked at it, and only then did they give it. So it's not, for Nagorno-Karabakh, it is certainly not automatic. There was another case of someone who was competing in an athletic event. It is simply the fact that we are discriminated against by other countries, Nagorno-Karabakhians, as a charitable act. Then there was the question about the minister statement. Well, he's a politician, isn't he? These sort of statements are made by politicians on all sides for nationalistic reasons. There are politicians in Azerbaijan who talk about bombing Nagorno-Karabakh and so forth. I should say that an inquiry has been made about the number of passports issued to Nagorno-Karabakhians, and it would appear that approximately 900 passports have been issued over the years since the agreement in 1998. And so given that there are about 150,000 Nagorno-Karabakians, that is, shows that it is, in fact, a very limited number. The conscript cases, I think you asked about one conscript case, the 1994 Status of Forces Agreement provides that, of course, the Armenian army, and it's got a court in Goris, which is in Armenia, just over the border, deals with discipline cases against Armenian conscripts who may be serving in the NK army. There was one case, in fact, where all the witnesses were in Stepanakert, and by agreement the court moved from Goris to Stepanakert. But for that, that was only one case. I gather it's the only case, and it was exceptional and dealt with witnesses. Finally, there was the question of the All-Armenian Fund, and I think you have a similar number. The document 12 in our submissions that we put on the portal on Monday, that it would appear members of the court have not been supplied with by the registry, show that there are comparable numbers, the amounts each year given by the Armenian diaspora, and so as are given by the United States Congress or Senate. So that concludes the questions. I will only comment that you've heard from the applicants that Charles Blandy's name crops up again. Who is Charles Blandy? This is the kind of thing they invite you to decide. A question as important as effective control by appeal to people about whom they tell you nothing, whose expertise is unknown, and of course you have the benefit of a very distinguished Romanian general who is an independent advisor, who has actually gone to both armies and looked at the evidence and has concluded that under no definition of effective control does Armenia have it over the Nagorno-Karabakh forces.
Thank you, Mr. Robertson. We have now come to the end of the hearing. I thank the parties for their interventions and answers to the court's questions. The court will now deliberate on the merits. The judgment will be delivered later. The parties will be informed of the date of delivery. I declare the hearing closed.